Shweta Khandelwal and I am the Principal Attorney at the Law Office of Shweta Khandelwal. My practice is devoted almost exclusively to US immigration and nationality law. Today we are going to talk about some options that are available in case a foreign national misses filing the H-1B visa on time and the H-1B quota expires. Well, obviously one can wait for a year and file for the next available quota. But are there any intermediate options? Turns out there are. Here are some of the options that could be potentially available to you. The L1 Intra-Company Transfer Visa. This visa is available in case a foreign national has worked for an overseas entity for at least 1 year and now wishes to work for a branch, subsidiary or affiliate of the overseas entity in the US. So for example, if you have worked for a company abroad for at least 1 year, you may have the option of working for a branch or a subsidiary of the company in the US. The TN visa. This is a visa available to Canadian and Mexican nationals under the North American Free Trade Agreement, popularly called the NAFTA Treaty. J1 training and other exchange programs. You could consider working on the J1 Exchange Visitor Program. The E1 or the E2 Treaty Trader and Treaty Investor visas. Depending upon the nationality of the foreign national, a person may be entitled to work in the US on the E1 or the E2 Treaty Trader visa. Australian nationals could consider working on the E3 visa. Persons of extraordinary ability could consider working on the O1 visa. You could consider returning to school to pursue a higher education and then work on the F1 optional practical training or the curricular practical training program that is available if you are working in a position that is related to your academic degree. The last option is having an employer file for an immigrant visa for yourself under the EB2 or the EB3 category of employment-based immigrant visas. Of course, these visas have a waiting time and may not be a convenient option if you wish to resume working in the US almost immediately. Depending upon the facts and circumstances of your case, there may be other creative options available to you. You should consider retaining an attorney who can work with you based on the facts and circumstances of your case. Regardless of what you do, I would strongly advise you not to work in the US without having a work authorization. Not even voluntary, unpaid or in an internship position. It is a myth that one can work without a work